So tonight I'm going to be talking to you about different ways of planning your estate. We'll begin by looking at 6 different ways. Everybody in this room is going to fit into one of these 6 categories. And then we'll be emphasizing different types of trusts, because the trust idea has been around for over 800 years. We got the idea from England, where it's been successfully used to reduce your exposure to taxes, to stay out of court, to save time, save money. And we'll be seeing the different types of trusts. We'll talk about the living trust compared to a testamentary trust. We'll talk about a legacy trust, also known as the triple generation trust or an ongoing trust. We'll talk about the funded trusts versus the unfunded trusts. We'll see their revocable trusts that become irrevocable, and then their separate irrevocable trusts all by itself. We'll see that the trust idea is not new. It's been around for a long time because it's been a wonderful way to save time and save money. We'll see that it can avoid the problem of the prodigal son, the parable of the prodigal son from the Bible. And that's the problem of giving money too early to your children or grandchildren. We'll talk about that. It can avoid the Groucho Marx problem, the problem of old age or conservatorship or dementia. And it can save taxes, or it can reduce taxes. In fact, there are plans that are available that would allow you to completely eliminate the death tax in America. There's no need to pay an inheritance tax. There's no need to pay an estate tax. There's no need to pay a death tax. It's simply a question of what type of plan you have in effect. The death tax rate is how much today? Who can tell me how much the death tax rate is?
0.
Death tax rate today is 45%, and it goes to 55% in 3 years. A 45% rate is not bad. I've been practicing for 39 years. When I first started practicing, the death tax rate, combined California and federal, was 77%. So we're talking about the taxes and how you can reduce or eliminate this confiscatory death tax. We'll talk about how the trust works. I'll give you some examples, who the trustee should be, who the successor trustee should be, how you fund the trust. We'll see that Proposition 13 is not a problem. We'll also talk about the best way to hold title to your assets. If you don't remember anything else I say tonight, and just remember there are different ways to hold title to your assets, and the best way in California is to hold title in both your names as community property. That's the best way to hold. Most people don't know how they hold title to their assets. How many people in this room hold title to their assets as their sole and separate property? How many is community property? How many is trustees of the trust? How many people don't know how they hold title? And after a couple of drinks, how many people really don't care how they hold title? All right, we'll be talking about that tonight as well. So we're going to look at different opportunities we have in planning our estate. And we'll begin with the most popular way of planning your estate. What is the most popular way of planning your estate? What do 70% of Americans do? 70% of Americans have no plan. No plan at all. But that's okay. Big Brother, the state of California, has taken care of them. Arnold Schwarzenegger has written a special plan for you. And it's the most expensive plan you can have. Maximum taxes, maximum fees, maximum delays. But that's the decision you've made. 70% of Americans die with no plan, the intestate arrangement. That's one way to plan your estate. Another way to plan your estate is to do it yourself. You don't need a lawyer. You can do it yourself. LegalZoom on the web says they'll give you a foolproof will. That's right, a foolproof will that's guaranteed to put you into probate and waste your time, waste your money. So what I'm saying is there are different ways to plan your estate. California is one of 17 jurisdictions that allow you to write your own plan, if it's entirely in your own hand script, and if it is dated and signed by you, it's valid. A recent Supreme Court justice wrote his own plan. He saved about $4,000 in legal fees. He was an excellent attorney in the field of corporate law, but he didn't know anything about estate planning. And the $4,000 fee that he saved by doing it himself in his own handwriting cost his family $400,000 in unnecessary taxes and probate fees. Chief Justice Warren Burger. Remember him? We read about him in the newspapers. But yes, you can plan your own estate. Next most popular way of planning your estate is what I call the sweetheart will. I love my spouse, I leave everything I have. Simple will. This is a witnessed will. And again, I want you to look as we go through these ways to see the different opportunities you have. Look at the costs. course, when we're talking about taxes saved, I'm talking about the death tax, also known as the inheritance tax, or the estate tax, or the inheritance tax, estate tax, death tax, all the same thing. So the first three arrangements, no tax savings. First three arrangements, you're not avoiding probate. First three arrangements, we're not avoiding the problem of guardianships when you leave money to minors. And a minor in this state is anyone under the age of what? 18. You got the court involved. The money doesn't go directly to the minor. The money goes into the court system. And you have to hire an attorney, and you have to hire somebody to come back and represent the minor and explain to the court how the money's being spent. And then, of course, when the minor becomes 18, what happens? He gets all the money. Conservatorship is not avoided. Of course, the fees are not tax deductible. And then we begin with more sophisticated ways of planning your estate. The Testamentary Trust. This is one way to plan your estate. This is what John Wayne had when he died. He had an estate of $12 million. And it cost his family $6 million in unnecessary taxes because he didn't do proper planning. And there's a probate right here in Orange County. The probate fee in Orange County was $250,000, and it took 6 years. But that was just a part of it. There's also a probate in Arizona, there's a probate in Nebraska, and there's a probate in Washington for John Wayne. Now, why did John Wayne have 4 probates? Because he had properties in these other states. So one of the reasons you might think in terms of doing trust planning is to take those properties and move them into your California trust to avoid out-of-state probates. But a testamentary trust is a type of trust that's contained in your last will and testament. And then it springs up out of your last will and testament alive, but it springs up in the Superior Court Probate Division. And in my opinion, that's the wrong place to go. The next few arrangements talk about ways we can stay out of court. The simple revocable living trust. Now this is for somebody that has less than $2 million. They're not concerned about tax planning because we have a certain amount of property we can leave tax-free today. How much is that? How much property can we leave tax-free at our death today? $2 million. And it goes up. January 1st it goes up to how much? $3.5 million. But just 1 year. And then 2010, we have no exemption amount because in 2010 there is no death tax. So if you're planning on dying, 2010 is the year. But don't die in 2011 because the exemption amount drops back down to $1 million. And the tax rate increases from 45% to 55%. Anything more than $1 million is taxed at 55% in 2011. That's the law that's currently on the books. Now, I think Congress will be meeting this next year and making some changes depending on whether or not it's President McCain or President Obama. I don't know who's going to be elected. But Congress needs your money. And the easiest way they can raise money is by taxing people that die because there's nobody there to complain. So Mark Twain told us there's not a more dangerous time for the American public than when Congress meets. So watch out. And then we have the standard revocable trust. This is sometimes called the AB trust or the ABC trust or the marital deduction trust. This is a way to save taxes, and this can save hundreds of thousands of dollars in taxes depending on the size of the estate. And it's an opportunity you have to protect your families, to stay out of court, to avoid guardianships, to avoid the Groucho Marx problem. This is what most people have when they talk about the AB trust, or you have a family that says, oh yeah, I have a trust. They usually have something called an AB, or the standard marital deduction trust. And then there's another opportunity I'd like to talk to you about, and that's the legacy trust or the dynasty trust. This is an opportunity to protect your family, to protect your spouse, and keep the family money together. I hear the same mantra from family after family. My goal is to protect first my spouse, everything goes to her, take advantage of the unlimited marital deduction. There are no death taxes at the death of the first spouse. But you've got to do some planning while you're both alive if you want to take advantage of the AB trust and get a double exemption amount. And then they want it to go on down to their kids. But most families, when you look at the trust, it says it goes down to the kids maybe at 30, 35, or 40. It spoon feeds it out to them. But what happens when the kids get the money? Well, sometimes there's a divorce. Oh, I know all your kids are happily married. But I hate to tell you, the divorce rate is 50%. I know all your kids are successful. They're not going to get involved in any lawsuits. But some of your children are architects or lawyers or doctors, and they do get sued. They're creditors' claims. And I know some of your children are successful. And what I'm saying is you have an opportunity in terms of planning your estate in such a way that you can continue the trust on after both of you pass on for the benefit of your children, protecting them against divorce, against creditors, against malpractice claims, against predators, and against the tax man. It's a question of how you plan your estate. So just imagine after the two of you pass on that rather than giving the money outright to your kids at 30, you put it in a cookie jar. And you can have each of your kids, after you're both gone, be the trustees that are a cookie jar if they're mature enough. Or you could have a third party as a trustee in the meantime. And that third party would step down when the kids reach maybe the age of 30 and would manage their own trust. The kids could get at the money, they get at the income, they could get at the principal. But by leaving it to them in this ongoing cookie jar, or the legacy trust, also known as a dynasty trust, it keeps it as their sole and separate property. It will not be commingled as community property. So that if there's a divorce later on, you have avoided the problem of commingling property. So this is important. You want to keep family money in the family tree. This is an opportunity you have. Second of all, if you leave it in the legacy trust, if you leave it in this cookie jar, and your son gets sued, or your daughter gets sued, the creditor will take everything they have. 24 million lawsuits were filed last year. 24 million lawsuits. Everybody is suing everybody. It's hard for me to give you creditor protection, but it's easy for me to give unbelievable creditor protection for your children, grandchildren, and great-grandchildren if you take advantage of this legacy trust. Also, when your children receive the money, let's say you leave each of them $2 million, doesn't matter what the amount is, in this cookie jar, and it's grown from $2 million during their lifetimes to maybe $4 or $5 million. We can create the trust in such a way that that money then drops down to your grandchildren, free of the death tax of 45 to 55%. And when the grandchildren get it, they can also get it in the legacy trust. They can be their own trustees. They can name successor trustees. They can avoid creditors. We can avoid divorce. We can avoid taxes and go on down to the great-grandchildren. These trusts can last for 90 years. Or I had a couple in last week and they said, well, 90 years isn't all that long. Can you get it going longer? And I said, sure. They can have Nevada law apply. It can last for 365 years after your death. 365 years. So these are just some of the options you have in planning your estate. But the tax savings, the creditor protection is mind-boggling with the legacy trust, and very, very few people have it. The very wealthy have it, but you don't have to be wealthy to have this type of plan. I had a widow come into my office recently in the Long Beach office, and here's her story. Her husband died. They'd done no planning at all. They were merchants. She comes in and says, all I have is $1 million. I probably shouldn't even be here. And here's my story. I've got 2 boys, good kids. One's on his 4th wife. And he has a couple kids, my grandchildren that I love. My other son is real successful. He makes lots of money. He's a plastic surgeon. But he's been sued about 25 times. And he loses all these malpractice claims. And he's got a couple boys. What am I going to do? All I have is $1 million. And I said, well, what do you want to do? I want to do what you want to do. She says, I want to leave money to my boys, but I don't want the pediatrician's wife to get it. That's a rocky marriage. And I don't want my plastic surgeon's son to get it because he's sued all the time. Then a legacy trust makes sense for you. But $500,000 that you're passing to each boy, they can be the trustee of their trust. They can keep it as their sole and separate property. If they get sued, the creditor can't get it. If there's another divorce, the ex-spouse can't get it. We protect the boys. We make sure it goes on down to the grandchildren at the ages you want and the great-grandchildren. So you don't have to be a Rockefeller or a Harriman or a Ford or a Kennedy to have one of these legacy trusts. In fact, my wife and I have one of these legacy trusts because I have 2 daughters and they're both dating jerks. Okay, so what are the 6 opportunities in California? We just looked at them. What is a trust? Well, if I strip away the fancy terminology, all a trust is an arrangement whereby you take property and transfer it to one person for the benefit of another party. So let me give you an example. What's your first name?
Ryan.
Ryan?
Yes.
Ryan, there's $100.
Thank you.
I'm glad you came today, Ryan. Now, Ryan, I'd like you to take that $100 and invest it wisely for the benefit of Bruce. And I want you to pay him the income each year, Ryan. And if the income is not enough, I'm authorizing you to invade the principal for his benefit. Now, what have I just done? I've created a trust. This is an oral trust. Are oral trusts valid? Yes, in California, oral trusts are valid up to $500. But let's look at the people here involved. First of all, the creator of the trust, I'd be called the grantor, or technically I'm called the settlor. Over here we have Ryan. Ryan is the manager in plain English, but we call him the trustee in trust language. And over here we have somebody that I call plain Lucky. But he's actually known as the beneficiary. Now, every trust by law has to have those three hats. But you can wear all three hats yourself. If you're single, you're going to wear all three hats. You'd be the creator, the manager, and the trustee. If you're married, you and your spouse together would wear all three hats. And you would appoint a successor trustee, which could be a son or a daughter or your best friend, anybody you want. It's entirely up to you. So this is a trust. What type of trust is this? Well, it is a revocable trust because all trusts in California are revocable unless expressly stated to be otherwise. So this is one, a revocable trust. Two, it's a living trust because it was created while I was alive, as opposed to a testamentary trust created while I'm dead. Okay, so it's a revocable living trust. Now, later on I may discover some things about Bruce that I don't like. Maybe he's voting for one of those propositions coming up the forthcoming election, something about letting animals out of the chicken coop and the cows out of the barn. I don't understand too much about this. I don't understand why I have to vote on that. But anyway, maybe that's something I don't exactly approve of, and so I have a change of heart and I want to revoke my trust. So Ryan, where's my money? Thank you. So it is with your own trust. You can make changes as time goes on. You can amend it. I think this is the reason it's lasted for so long. So we're talking about a revocable living trust that you can set up while you're alive as opposed to a testamentary trust. A testamentary trust is one way to go, but it's not the best way to go. And the reason I found out about that is both my parents died in a plane crash, the Canary Island plane crash. And they had gone to a CPA, tax attorney, who set up a plan for them. They had created something called a testamentary trust. And I thought that was a pretty good plan, but I was not an expert in this area. I was doing litigation in the district attorney's office. My parents died unexpectedly. All of a sudden I discovered I had to go to the Superior Court Probate Division to claim my inheritance. I had to give the court $50,000 in fees to claim my inheritance. I had to wait for 3 years to claim my inheritance. And suddenly, I started doing some studying and discovered, hey, there's a better way to plan the estate, and that better way is a revocable living trust. So if you have a testamentary trust, run. It's the wrong way to plan your estate, in my opinion, because it forces you into probate. We know they're both revocable and irrevocable trusts. If you have a larger size estate, you probably have a series of trusts. And then funding versus unfunding. It's so important to fund the trust. And let me show you what I mean by that. It's one thing to have a trust, it's something else to make sure all the assets are in the trust. So Ryan's going to help me for a second. He's going to bring his trust into my office, and I'm going to ask him, Ryan, are all the assets in the trust? First of all, here's what a trust looks like in plain English. All it is a box, a container for your assets. Nothing more fancy than that. If we strip away all the fancy terminology. And tonight I'm talking in English. So Ryan, welcome. Here's your trust. The first question I'll ask Ryan is it funded? And I'm amazed at the number of clients who look at me and say, what are you talking about? Funded? I don't know what you're talking about. I'm asking you, have you transferred title into the trust? That's so important. The trust won't work unless you have the assets in the trust. So what do you think Ryan's biggest asset is? Probably his house. Here it is. Probably held in joint tenancy, which is an income tax trap and a death tax disaster. You don't hold appreciating assets like your house or stock market portfolios in joint tenancy. You're shooting yourself in the foot. We'll talk about that in just a few minutes. We want to make sure the house is transferred from joint tenancy to community property into the trust. Now, we're funding the trust. Any increase in property taxes? No. Revenue and Tax Code Section 62. Who held the house before it was in the trust? Ryan and his spouse. Who owns the house now? Ryan and his spouse. No increase in property taxes. Ryan may have some other buildings. He may have a little commercial building. Here you go. Same thing. We do a grant deed, changing title from joint tenancy to community property, moving it into the trust. Now I know Ryan may have some good investments, and remember that $100? It's grown a little bit. So Ryan's going to take a copy of the trust down to the bank manager and change title of those CDs, savings accounts, to his name, his wife's name, trustee of the trust. All major assets are going to go to the trust. And I know that Brian has been interested in the stock market, making some wonderful investments. Can't go wrong with that. These always pay excellent dividends. These are my favorites too. Now, Brian may have taken some mortgages back. He may have sold some property and taken some trust deeds back. Well, we just do assignments of those trust deeds into the trust. We have no problem with that, okay? So all major assets are going to the trust. We'll do a lump sum transfer of all the personal effects, furniture and jewelry, right into the trust. A couple of things stay outside the trust, though. Qualified plans, 401ks, 403bs, IRAs, KEOs stay outside the trust by law. Primary beneficiary should be your spouse, so she can roll over tax-free. Secondary beneficiary, the children, for the stretch-out possibilities. So one thing that stays outside the trust are your qualified plans. 2, cars normally stay outside the trust, even if you have a great big fancy Lexus. Why? Because there's no probate on cars. Cars should be held with you and your spouse in joint tenancy, so it automatically goes to the survivor. It's a depreciating asset. Okay. Third of all, we want to make sure the annuities are held outside the trust. And fourth of all, we want to make sure we have one checking account outside the trust. Because when you die, there'll be checks coming in your name alone. If we can have one checking account outside the trust in both your names, then the surviving spouse can write for deposit only and clear those checks. So those are the 4 things that stay outside the trust. Everything else should go into the trust, even including Ryan's boat. We want to get this in the trust too, so all major assets will go in. Now later on, what may happen is Ryan may decide, I want to refinance that building. Well, that's no problem. He can go to a bank and have it refinanced in the trust, or the bank may say, well, let's just do a quick claim deed and take it out of the trust and refinance it. Either way, no problem. But if you take it out of the trust to refinance it, just make sure you put it back in. Because if you die with outside the trust, you see, the poor over will pick it up and put it in, but it costs us a probate. So we want to make sure all major assets are in the trust. And then later on, if Ryan decides to move out to the desert and buy a piece of property out there, he'll buy it immediately in his name as trustee of the trust, so the new property goes in the trust. So this is a graphic illustration of how important it is not just to have a revocable living trust, to make sure it's properly funded. We want to make sure it's properly funded because we want to avoid probate, and probate's expensive. Probate fees are set by statute that is based on your gross estate. So let's say that you have a home worth $1 million and you have a mortgage against that home of $1 million. What's subject to probate when you die? $1 million. So the cost of probate would be how much? $46,000 plus a minimum of a year. We're trying to avoid probate. There's no reason to go to probate. It's an antiquated process that can't be avoided and should be avoided. So add up the size of your estate. What is it? And then look here at this chart and look what you're losing unnecessarily. These are the state mandated minimum fees. These are minimum fees to go through probate. They're extraordinary fees that are not even listed here. So you want to plan your estate in such a way to avoid probate. And if you have property in Iowa, or if you have a timeshare in Hawaii, you've got to plan your estate to make sure the property in Iowa, the timeshare in Hawaii, get into the trust to avoid probate. Otherwise, you can have probates in these other jurisdictions, just like John Wayne did. Okay, so privacy. Is privacy important for you? A trust gives you privacy. Nobody else will know the size of the estate or where it's going. But if you're going through probate, anybody can go down to the courthouse and look up the size of the estate. And I've done that on John Wayne. It makes for a very interesting reading. I got a great big pile of papers like this. And I learned all sorts of details about his habits that I don't think he'd like other people to know about. But it's a public record. And if you're famous, like John Wayne, they go down, they go through all the paperwork, and they write about you in the newspapers. So another advantage to think in terms of a trust is to achieve privacy. Save time. Do you want to put your kids through the agony of probate? Do you want to send them over to the Superior Court Probate Division during the next year or two? Or do you want to simply give them the assets immediately to save time, achieve privacy, save money? And the court system doesn't work very well. if all my papers are prepared to go see the judge, it takes me 8 weeks before I can make an appointment with him. And then occasionally, when I get to the Superior Court Probate Division, on the 9 o'clock calendar, I have to wait around for an hour or two. I'm not the only person over there. There might be 60 or 70 other attorneys on the calendar. And then I wait around for an hour or two, and then he may have lost the file. Now, that's not funny because my client's not happy, I'm not happy, but that does happen. So why don't you make decisions in advance so you don't have to go to court? Why don't you save time? Why don't you save money? This is an opportunity you have. Avoid the problem of the parable of the prodigal son. Now, in the Bible, the story of St. Luke, I'm sure that you remember from Sunday school, there are two boys out there on the farm working with Dad. And one of the boys comes in and says, "Hey, Dad, I hate this work. My back hurts. I'm sunburned. My hands are blistered. I'm not cut out to be a farmer." And the Bible says, well, Dad looked at him. He says, "You know, you really aren't cut out to be a farmer. What do you want?" He says, "I'd like my money now to make an investment." And so the Bible tells us he got his inheritance early. He goes on to the next village, and he loses everything he has through wine, women, and song, gambling it all away. He came back in rags as a beggar. That's the story of the prodigal son. So what I try and tell clients is you don't want money going prematurely to your children or grandchildren. You should set some sort of age at which they get it, where they be mature enough to receive it. And during the last 39 years of my practice, I haven't met any kids or grandkids under the age of 30 who know anything about anything, let alone about money. But I'm always flabbergasted by my clients to say, "Well, give it to them at 21. And I say, "You've got to be crazy. 21-year-old, what's he going to do with the money? You tell me."
Buy a car.
Fast car. You got it. So there are better ways to protect that child, and I suggest you think in terms of a trust, and we can incentivize these trusts. In other words, we can say to the kids and the grandkids, "Well, we'll give you money from the trust when we're gone, but it's based on your AIG. How much money do you make?" And the trust will match that. And if you don't make any money, you don't get any money from the trust. So let's look at the tax returns. So the different things we can do depending on what you want to have happen. We don't have to have silver spoon children. We don't have to have silver spoon grandchildren. We can give them some get up and go. Avoid the conservatorship problem. That's the problem of old age. And what I'm trying to say here is we don't want to get caught up in an expensive Groucho Marx type proceeding. That's the problem of the conservatorship. Later in life, the court may get a hold of you and claim that you're not all there. And the court, that is the judge, will appoint somebody to manage your affairs for you. You have to hire an attorney and accountant, come back on a regular basis and explain how you're spending this money. This is exactly what happened to Groucho Marx when he was 88. He had a young gal move into his house, and all of a sudden all sorts of things happened, and he was hauled into the court. And he went through a rigorous examination, and he testified that yes, he was old, he was forgetful, and he was difficult to be with, but he was perfectly competent and knew exactly what he was doing. Unfortunately, after about a $300,000 legal proceeding, the court disagreed, took all the assets away from him, appointed a conservator of the person, conservator of the estate. Very messy, very sad, all very public. It could have been avoided with proper planning. The Groucho Marx problem, the problem of the conservatorship, should be avoided. All a conservatorship is a probate that happens to you during your period of incapacity. So you can plan your estate in such a way to avoid it. Saving taxes. Now we're talking about, of course, the death tax. This is the confiscatory tax, and it's really a double tax. And why is it a double tax? Because you've already been taxed on that money once, and you paid income taxes on it, and now at the time you're passing, the government comes back and wants to tax you again. So what I'd like to do is graphically compare a Sweetheart I Love You will with an AB trust that doubles the exemption amount, and basically show you in plain English how the trust can save you taxes. So I'll just assume that we have an estate of like $3 million, and we've written it all down this sheet of paper. And some of you have a simple auto-spouse type of arrangement, a Sweetheart will, and I want to show you why that's not the best way to go. So the husband dies first. He has how much of the estate? Half, because we live in California, community property jurisdiction. If he has a Sweetheart will, he says, "I love my sweetheart. I leave everything I have." All he does is merge his half into her half. $3 million estate. The exemption amount is how much today? How much? $2 million. Excess is taxed at what rate? 45% going to how high? 55%. Stupid planning. Doesn't want to do that. What you should do with proper planning is say, I want to plan my estate the smart way. I'll leave my share of the estate to my spouse in trust. I'll give her the income. I'll give her the principal. She can spend it all if necessary. It's hers, but it will not be includable in her estate. It's kept separate so that my $2 million exemption is protected. She gets a $2 million exemption. We protect $4 million. What does that mean? In a $3 million estate, we've saved $500,000 in taxes. $500,000 in taxes and probate fees. If you don't have this opportunity, you're just taking $500,000 and just throwing it right out the window, needlessly. Doesn't make any sense. So when we think in terms of a trust, of course, we're talking about other ancillary documents that go with a trust. You'd always have a will in conjunction with that trust. A special type of will called a pour-over will, picking up assets you forgot about and moving it into the trust. So if you die, you don't have all the assets in the trust. The will pick it up, represented by this glass of water. Here's your trust. The purpose of the will is to pour it into the trust. We call that a spillover will. We'd also have, I hope, a community property agreement confirming everything is community property. So there'll be a double step-up value and basis of the death of the first spouse to eliminate the long-term capital gains tax of 15% that one presidential candidate has promised will be doubled as soon as he's elected. Doubled. The long-term capital gains tax today at 15% is the lowest it's ever been. So just pointing that out to you, taxes are going to be going up soon. California has a tax of 9.3%. So if you want to avoid the California tax of 9.3% and the 15% tax going to 30%, you might think in terms of having a community property agreement, confirming everything is community property, so that after the death of one of you, the survivor can liquidate the estate income tax free. That's an important provision. Do you have a notarized community property agreement? That's a separate agreement, separate from the revocable living trust. That's very important to have, in addition to the pour-over wills. And then you all remember Terry Schiavo. Who is Terry Schiavo? She was that gal down there in Texas that was brain dead for 13 years. President Bush had to fly back from the ranch and make some sort of pronouncement about it. Congress stopped, tried to pass some rules about her. For 13 years she was brain dead. Now, she did not have a written advanced health care directive. And so the question is, who could turn off the machine? And finally, the machine was turned off. She died, but she went bankrupt. Her husband went bankrupt. Her parents went bankrupt. It's not what she wanted, but it's what happened. You don't have to end up like Terry Schiavo. You can do a special written document called an advanced health care directive, and you can appoint somebody to make health care decisions for you in the future. So you can get the machine turned off once you're brain dead. It's just a question of what type of plan you have. Now, some people go on the internet and they get something called a directive for the physician or a living will, which are invalid. You can still buy these, by the way, on the internet, but they're invalid since July 1st of 2000, but people still buy them. They have nothing to do with what I'm talking about. I'm talking about an advanced health care directive. It should be current. The old ones had a statute of limitations of only 7 years. So you want to have an advanced health care directive to get off the life support system. Also, you want to have a power of attorney. The power of attorney says, if I can't sign my name in the future, I want my spouse or somebody else in my family to step forward and sign my name. I don't want the judge making any appointments. I'll make the appointment in this document. This helps you avoid a conservatorship. Again, keeps you out of court. So these are options you have in terms of planning your estate. How does a trust work? Well, I think we've seen a demonstration of it. You can be your own trustee, you and your spouse together. Something happens to one of you, the survivor takes over. Otherwise, you can name successor trustees. What property should you put into the trust? All major assets except for what? Cars, qualified plans, annuities, and one checking account. Everything else goes into the trust. Is Proposition 13 a problem? Proposition 13 is not a problem because there's no increase in property taxes. Simply a question of how you hold title to your assets. Joint tenancy versus community property. Well, how do you know how you hold title? Well, look at your monthly statement from the stockbroker. Look at the grant deed. If it says husband and wife with right of survivorship, what does that mean? That's joint tenancy. Or it might just say husband and wife as joint tenancy. That's not the best way to hold title, because you're going to be paying unnecessary income taxes after the death of one of you that could otherwise be eliminated. And also, it gums up the AB or the ABC trust, because the assets won't go to the A and the B trust. It goes automatically to the surviving spouse outside the trust. So it is an income tax disaster and a death tax tragedy. You don't hold appreciation assets in joint tenancy unless you don't like your spouse. Let me give you an example here. Let's say you bought some assets a while ago for $50,000, and today those assets are worth $250,000. If you sold that today, what's your exposure to tax? The difference between your cost of how much? $50,000. The price it goes to, $250,000, is a long-term capital gains. Okay, so that is going to be $200,000 subject to tax. But if you hold on to that same exact asset until one of you dies, the tax is dependent upon how you hold title. If you hold title in joint tenancy, you see, you only get a partial step-up value and basis for the decedent's half. The survivor's half is not stepped up. And so then, example, the surviving spouse goes to sell that asset, she has to pay $100,000 in unnecessary exposed to taxes. If she held title as trustees of the trust, within the trust as community property, you get a double step-up value and basis, so the surviving spouse could sell it income tax free. So that's something important to think in terms of and how you plan your estate. What happens to your estate at death? Well, here is a clear, precise example showing you that your business interests, your life insurance, and by the way, the IRS collects more money in taxation of life insurance than any other product because people don't hold it correctly. Life insurance is part of your estate. Your real estate, your personal property, all come to this funnel. If you're not careful, a lot of this money goes out in death taxes, accounting fees, appraiser fees, probate fees, attorney's fees, executors' commissions. I'm here tonight to say, with proper planning, you can reduce these streams and get a lot more to your family than just a partial portion of your estate. You can get everything to your family. It's a question of how you plan your estate. What happens if you both die today? Well, here's some examples in terms of the size of the estate. $2.5 million. Taxes on a simple will would be $230,000. What's the taxation for the trust? $230,000. If you have a $4 million estate, you can save almost $1 million. So taxes can be reduced or avoided with proper planning. And as we've already seen, probate is voluntary. You don't have to go through probate in California. Just a question of how you arrange your estate. Now here's an example of what happens at the death of the first spouse. You know, a lot of people have the living trust myth. I have a trust, my spouse dies, I don't have to do anything. That is a myth. When somebody dies, there's certain things the surviving spouse has to do. One of the things that she has to do is appraise the assets and then decide where the assets are going to go. If you have an AB or an ABC trust, you've got to decide what assets are going to go into which trust. Now, it's pretty simple to remember this. When your husband dies, and I assume the husbands die first because that's normally what happens, his portion of the assets would go into Trust B. Trust B is not complicated. Trust B stands for below ground. You got that? B's for below ground, okay? Now, your husband may be concerned about your future spouse. He may have incorporated the anti-gigolo provision into your trust. If you don't have one, I recommend it. Anti-gigolo, that's very important. That's Trust C. Or it could be called the anti-floozy provision. Depends on how you look at it, okay? Now, the surviving spouse's share goes where? It goes into Trust A. And A stands for what? Above ground. Very good. A is above ground, B is below ground, and C is the anti-gigolo or anti-floozy provision. So the surviving spouse has the use of all these assets. She has all the income, she has all the principal. And then, if she has to get at some of the principal, she can move the assets around as she sees fit. But these two trusts become irrevocable. And so, since the husband's died, his Social Security number was buried with him. We have to get a taxpayer identification number here, get a taxpayer identification number here, and we got some fiduciary income tax returns we have to file. And the surviving spouse will continue to use her Social Security number and file a 1040 and 540 here. And then it's simply a question at her louder passing, what happens? We hope it'll continue in trust for the benefit of the children with a legacy type arrangement, triple generation type arrangement. So we've been looking at different ways to plan your estate. And it's mind-boggling if you just take $500,000 invested at 7%, what can happen with that money with a legacy trust compared to a regular trust. What's going to be the net to the heirs? Without a family legacy trust, great-grandchildren will end up with about $3.5 million. With a legacy trust, the great-grandchildren can end up with almost $29 million. So these legacy trusts, dynasty trusts, are what people should have in planning their estate, and you don't have to have a multi-million-dollar estate. Talking to attorneys who don't understand taxes, they often say, oh, unless you have a $10 million estate, you don't need a legacy trust. Doesn't know what he's talking about. These trusts are unbelievable, even for the smaller size estates, in terms of how you plan your estate. The trust can be set up to protect you with durable powers for health care and durable powers for property. Recognize anybody here? Now, you may think this is funny, but I can't tell you the number of cases I've had in my own office where people say, oh, I love my wife, we've been married for 50 years, nothing like this is ever going to happen. It does happen. So we want to avoid the floozy, and we can with proper planning. We can make sure that when one of you dies, the decedent's assets become irrevocable, and we can avoid not only lawsuits, but we can avoid the floozy from stepping in. We can also protect your children against lawsuits, against bankruptcy, against divorce. You know, your kids may be doing great today, but we don't know what's going to happen tomorrow. A lot of families are hurting now. A lot of kids have lost their jobs. And that's the number one cause for divorces, financial problems. If you want, we can also protect the grandchildren. Why not? Why not keep your family money in the family tree? Not just for you and your spouse, but for your children and grandchildren. This is the opportunity you have to pass it on for the next 90 years after you're gone. So I want to say to you, I appreciate you coming tonight. And there's one other thing I'd like to make an offer to you, and that is for those of you that become my clients, I want to show you something I have and I carry around with me in case I have an accident. You know, when you get to the hospital, what's the first thing they ask for you when you check into the hospital? Your insurance card. How are you going to pay for that? What's the second thing they ask for? Exactly, the durable power of attorney for health care. Well, you just had a heart attack on the golf course. Do you have that? I don't think so. But I'm doing something brand new for my clients that are coming in to see me. I have a special emergency access card. And that is a card that you can access on the web with a toll-free number. Within 5 minutes, they'll send you your durable power for health care any place in America, 24/7, 365 days out of the year. I don't know any other attorney is offering this to his clients. This is a fantastic opportunity. And on this card it says, who's the agent? Who's going to make the decisions for you? It also says, what allergies do you have? What other conditions? And you can write in anything else you want at the back of the card. So this is totally unique, and I think this is an important attribute of planning your estate. Everybody should have one of these cards. And let me just mention one other.
Is that a new thing?
Yes, brand new.
See, this is why I like this guy. He's always coming up and doing these innovative things. I mean, think about the times you're traveling. I mean, I think Bob, I was talking to you and you were in the hills of Texas a couple weeks ago. Okay? I know I've been talking to clients that are on chairlifts in Utah. And you know, it's nice to have something like that, especially if the ski patrol has to pick you up.
Thank you. Let me just mention a couple things in conclusion. Estate planning is very cost effective. Let me just point out a couple things for you. Simple probate avoidance trust could save you $50,000 in probate fees. You're looking at maybe spending $2,500 to set up a simple revocable trust with a couple grant deeds, durable powers for health care, durable powers for property, community property agreement. An ABC arrangement could easily save your family $300,000 to $500,000. You're talking about $4,000. Income tax deductible to set it up. A legacy trust can save your family millions of dollars. $6,500 to set it up. $6,500 and a 90% tax write-off. 90% tax write-off. So does it make sense to spend $6,500 to save millions of dollars for your family to make sure the family money continues in the family tree? I think it does, and that's the reason our family has one of these plans. Now, I'll be glad to meet with you on a courtesy basis Johnny is here from my office. He has the sign-in book. The only thing I ask is before you come into my office, make sure that I have an opportunity to review your wills and trusts. There's no cost for this meeting. I'd be glad to meet with you. I know some of you are not going to sign up tonight, and what will happen is then I will call you, you'll call me, I'll call you, and we'll play telephone tag. So I'm just saying, for those of you that like to take advantage of this opportunity, I'll be glad to meet with you. I'll sit down at no cost, no obligation. I'll look at your documents, and I'll tell you, here are the problems that I see. Here are the possible solutions I envision. Here's the cost, and then you make the decision whether or not you want to go forward. I've been doing this for 39 years. This is all I do. I'm on a first-name basis with the Chief Tax Collector for Southern California. If you got a problem, I know the boss. I get right through to the boss. So I'm just saying I've got a lot of good experience. I'd be delighted to have you as a client or meet with you and help you with any of the problems you have. So tonight we've been talking about different ways of planning your estate. We've been talking about the John Wayne problem, his problem, 4 probates, paid unnecessarily $6 million in taxes. Bing Crosby had a similar problem in 1954 when his first wife died. What was her name? Dixie. Didn't do any planning. Default will, intestate arrangement, very expensive. So he finally got some good tax advice and set up a revocable living trust to save taxes and save money. So we've been looking at 6 different opportunities in California. We know the first 3 ways of planning your estate: the intestate arrangement, the holographic will, the sweetheart will, are expensive arrangements. And the next type of arrangements are better ways to plan your estate: the revocable living trust, the ABC trust, the legacy trust, because it allows you to reduce or to eliminate taxes, probates, and conservatorships. We've talked about different types of trusts, contrasting living trusts that you set up while you're alive with testamentary trusts that come into existence at your death. We've seen how important it is, with Ryan's help, to fund that trust. We know some trusts are revocable that then become irrevocable to avoid the gigolo or the floozy. We've seen that the trust can give us privacy, it can save time, it can avoid probate. We also know that it can avoid the problem of giving money prematurely to our children and grandchildren. It can avoid the problem of Groucho Marx. And the death tax in America is a voluntary tax. It's a question of what type of plan you have in effect. It's an unnecessary tax that can be completely eliminated with proper planning. And we've seen who the trustee of the trust should be, how it works. And these trusts are just as effective for single people as they are for married couples. In fact, for single people, they sort of act as a prenuptial agreement. Very smart to have your own trust. And finally, if you don't remember anything else tonight, just remember joint tenancy is the wrong way to hold title. Don't hold title to your assets in joint tenancy. It causes unnecessary income taxes and death taxes. Thank you very much for listening to me speak on the John Wayne problem and the Bing Crosby solution.